is my first presentation in my entire life, so I'm under the stress. My English is not so well like yours, but I will read what I write. So first of all, I want to say something about this course, because this course is in memoriam of Professor Kačić, isn't it? Yes. And this is a little story about Professor Kačić, because he lived in the suburb of Dubrovnik called Mokošica, and during the Second World War, there was bombing and shelling that area in Dubrovnik, Mokošica, and my mother was a little baby, and she lived next house to Mr. Professor Kačić's house, and during the shelling, he put my mother on the neck and ran into the forest. This is a little story about Professor Kačić, who was 11-year-old boy, and he was very brave and saved my mother. Okay. We talk about special features of vessel leasing contract in legal transaction in the Republic of Croatia. Development of leasing business and legislative framework in the Republic of Croatia is, in the Republic of Croatia, the Leasing Act from 2006 was originally adopted and was in force from 2006 to 2013. Until then, there was no special law that would regulate this activity. It was replaced by a new law in 2013. On the Croatian leasing market today, there are 14 companies with headquarters in Croatia, and all companies are members of the Association of Leasing Company, which operates under the Croatian Chamber of Commerce, which was founded in 2002. The Croatian leasing market includes both operational leasing and financial leasing. Specification of vessel leasing contract. First of all, something about general information on the main rights and obligation of contract on financial and operational leasing in the business of indirect and direct vessel leasing. For discussing the vessel leasing contract and its characteristic content in terms of rights and obligation, it is of decisive importance whether it is a direct or indirect leasing business. In the essence, the business of indirect vessel leasing is such a business in which, in addition to the lessor and lessee, the supplier or manufacturer of the vessel also participates. Indirect leasing is a more frequent leasing business compared to direct leasing in business practice, especially in the Republic of Croatia. When discussing the characteristic content and essence of the vessel leasing contract in general, it is important to note here that the interpretation of the contract as a whole and its individual provisions. The legislator always implies the interpretation of the contract in such a way that he approaches it separately in each individual case, taking into account the particularities of the specific contract or legal transaction. The same is true of vessel leasing contracts. Applicators of the norm determine in purpose between the parties in each case separately. The business role of the leasing provider in the business of indirect vessel leasing is to finance the purchase or production of the vessel chosen by the lessee and to enable the use of the vessel throughout the duration of the leasing contract. That is why the division of leasing into direct and indirect depends on the particularities of the legal transaction, that is, the leasing contract. Another spectrum of observation of the leasing contract refers to the division of the work of financial and operational leasing. This division is based on the different division of investment risk in these deals, which is particularly sensitive in leasing deals where the leasing object is a vessel and affects the characteristic content of the leasing contract concluded by the provider and the lessee. For example, it does not affect the main obligations of the contract parties to the contract about leasing. In the business of direct leasing, in addition to the leasing provider and the lessee, the supplier or a vessel manufacturer does not participate as a third party of participant in the process, which is why the content of the main obligation of the leasing provider and the lessee in the contract concluded as part of the direct leasing business necessarily different from the content of the main obligation contracting parties to the leasing contract concluded as part of the indirect business, leasing business. As in business of direct leasing, the leasing provider is already the owner of the vessel that meets the needs of the lessee because he is the manufacturer of the leased object. The leasing provider is not obliged to buy the vessel for the lessee, that is, he has no obligation to finance it. About the secondary obligation in the leasing contract in the context of the specifics of vessel leasing. Regardless of whether it was a direct or indirect financial leasing, the secondary obligations are the same. It should be noted here that certain secondary obligations of the contracting parties to the leasing contract are characteristic of each leasing contract, regardless of the type of leasing business in which the leasing contract is concluded. In the business of indirect leasing, the lessor specifically assigns to the lessee his rights that he has on the basis of responsibility for defect towards the supplier of the vessel as well as the seller of the vessel. This means that the lessee is authorized on the basis of the leasing contract. For example, entering into a legal leasing transaction to invite the supplier or manufacturer of the vessel to remove the defects that he noticed on the vessel or related to vessel. It is a special feature of every leasing contract, regardless of the leasing business in which the leasing contract was concluded, that the obligation to maintain the vessel in good condition during the duration of the leasing contract and the obligation to perform the necessary repairs on the vessel are not obligations of the lessor, but the obligation of the lessee. In the leasing contract, the lessee obligates the lessor to enter into an insurance contract for the leased object with the insurer for the benefit of the lessor as the insured and undertakes to the lessor to fulfill the concluded insurance contract, for example, to pay the insurance premiums. The same is true of vessel leasing contract. The obligations of the lease to conclude a vessel insurance contract and to pay insurance premiums are secondary obligation of the lessee from the leasing agreement, for the fulfillment of which the lease is not entitled to special compensation as a contents measure, nor is entitled to compensation for the cost incurred in fulfilling this obligation. So the main thing of this presentation is particularly this in the general condition of the vessel leasing contract. First of all, based on the analysis of general operating condition of leasing companies, which make up the vast majority of the vessel leasing market in Croatia. Here we will point out different approaches in contracting specific rights and obligations in relation to the vessel leasing contract and in relation to other movables that are included in the general operating condition of leasing company. These specific rights and obligations in the vessel leasing contract are actually contractual particularities that, given the nature of the leasing object, the lessee have. It should be noted that only one leasing company has special business condition for vessel and special business condition for other movable property. It is precisely on this inconsistency that the author that I point to the diversity of the business practice of contracting vessel in Croatia. That is why the specific elements of the vessel leasing contract are below on the side, which in a certain way separate the contract of vessel leasing business from other movable assets that the leasing company leaves to the lessee. First of all is obligation to contract specific vessel insurance. Due to the way it is used and its technical characteristic, the vessel must be insured against various risks. In the research of business practice, it is noticeable that vessel insurance is especially indicated as an important determinant of the contractual relationship. In addition to leasing companies that specifically contract general operating condition for vessel, separating them with special operating condition from other movables. Leasing companies that have unique operating condition for vessel, vehicle, and other movables also emphasize the obligation to ensure specific risk in their provision of general conditions. In regular, the vessel is exposed to different risks for people on it or outside it, as well as things on it or outside it, as well as the overall environment. Therefore, contracting is logical and necessary. Second is determining the home place of the vessel. The concept of home location in the business practice of vessel leasing represents facilities suitable for housing vessel on the territory of Republic of Croatia. With regard to the purpose of the vessel, it's logical that such a leasing object, by the nature of things, comes from a home place, that is, from the territorial water of Croatia. Certain leasing companies stipulate in the general terms and conditions of business the obligation to give the prior consent of the leasing provider. For example, the leasing company for the departure of the vessel outside the territorial water of Croatia. The totality of nautical, legal and economic risk that such a voyage may bring, as well as the business circumstances of the lessee during the duration of the contract, which may be reflected in the orderly fulfillment of the rights and obligation of the contractual parties in the leasing business, necessarily require the prescription of such contractual provision contained in the general condition business. The third is place of handover of the vessel. The handover of vessel as an object of leasing in the context of the rights and obligations of the contracting parties had its specificity in relation to vehicles and other movable properties, precisely because of the complexity of the vessel handover procedure. It often happens in the business practice of vessel leasing that the leaser provider and the receiver cannot reach an agreement on the place of taking over the vessel. The supply of vessel and the manipulative capabilities for port facilities, which sometimes due to their characteristics are unable to prepare the vessel for takeover or require additional cost that the lessor doesn't not want to assume, require the contracting of provisions that put the lessor in a more favorable position through the general terms of business. Namely, in contracting the leasing business, certain leasing providers specify the agreement on the place of handover as the initial option of the terms of business. If an agreement cannot be reached, the place of delivery is considered to be the one specified by the leaser provider. Here, in cost to other leasing object, where the place of handover is the place determined by the leasing provider, the possibility of agreement between the recipient and the leasing provider, who could agree on different delivery location with each new contract, is agreed about vessel leasing. Holding of navigation documents. Navigation documents and other documentation accompanying the vessel must be kept safe with the lessee. This is the usual contractual provision from the general terms and conditions of the leasing provider, which is prescribed in all the general terms and conditions of the observed leasing company. Some leasing company also agree to keep a copy of the keys outside the vessel. This contractual provision results from the protection of the insurance provider against the impossibility of realizing the insurance when the insurance does not cover certain adverse events, when the navigation documents and other documentation as well as the keys are on the vessel at the time of the adverse event. In this case, the general condition determining that the lease is responsible for the damage. Obligation to inform about a traffic accident. This obligation of the lessee of the vessel corresponds to the obligation to inform the lessee of the vehicle when the traffic accident occurs. It often happens that the use of boats leads to harmful events similar to the use of vehicles. However, there are certain differences in such situations that should be pointed out there. The natural environment in which a boat is regularly used is significantly different than of a vehicle. Roads on which vehicles are used are man-made structure with the adjustment necessary for safe driving and use. Opposite, on the other hand, the water surface is not like that. In the sensitive or hydrometeorological condition, the changes of which case in instability for the regular use of the vessel, and as such is a significantly greater risk than is the case with vehicles. Procedures of determining the circumstances of the occurrence of damage are different for vehicles and vessels, and the limits of liability and realization of insurance depends on them. 6. The defining of business of vessel leasing or vessel leasing contracts. In determining of work of vessel leasing and vessel leasing contract, individual leasing companies have a unique approach. However, there is a clear distinction between a leasing business and leasing contract. There are two terms that cannot be synonymous in terms of content, but which business practice sometimes equates regulating through the general terms and conditions of the vessel leasing business. Certainly, the vessel leasing business is a set of action and procedures undertaken by the participants in the vessel leasing business, which in addition to the main action related to the conclusion of the vessel leasing contract, also include the conclusion of other named contract of autonomous commercial law, primarily the purchase and sale of vessel. In the regard, the terms vessel leasing business is particularly expressive in the business of indirect leasing. In addition to contracting the vessel, leasing business also assume various negotiations, information, and all those procedures that are concluded by concluding a vessel leasing contract. On the other hand, the leasing contract is the final act of the leasing business, which is conceptually narrower in comparison to the leasing business. It represents the totality of all procedures in the leasing business by which the parties regulate mutual rights and obligations. On the end is the obligation to accommodate the vessel in safe port. This secondary obligation in vessel leasing is actually very important. Following on from the previous discussion of the obligation to determine the vessel home place, this obligation is specific to the mooring in the port that has all the relevant permits for receiving the vessel. For example, that it is maritime safe under normal hydrometeorological condition, establishing a legal and maritime safe connect in ports and above all in nautical tourism ports is a logical business and legal obligation prescribed by a leasing company for several reasons. Namely, the insured risk assume that at the time of the harmful event and the damage that occurred while the vessel is in the berth is in a port that is qualified to receive the vessel. This doubt is further reduced by the fact that such a port also had permits to accept vessel from the relevant authorities. Such permits are, for example, concession. And we have a conclusion of this presentation. The leasing contract is generally a newer type of contract that has its own physiognomy. It is the main of sometimes the only contract in the legal business of leasing. Within this group of leasing contract is also a vessel leasing contract, which also has its own peculiarities. The vessel leasing contract in Croatian law is a standard and standard contract that is connected with rental, lease, and sale, and as such form the backbone of leasing as a separate form of contract determined by specific content. So for example, a type of contract regulated by a law to which business practice has given a special characteristic content by which it differs from other leasing contracts, especially with the general condition of business of leasing company. Contracting of vessel leasing, as the case of contracting when other movables are object of leasing, is always through the acceptance of general terms of business. This makes it impossible for the future lessee to negotiate in the specific leasing business. With the vessel leasing contract, the lessee undertakes, after the lessee has previously selected the vessel according to his needs, to acquire the vessel from the supplier or manufacturer into his ownership and hand it over to lessee for use for a certain period of time, and the lease undertakes to pay the lessee compensation for leasing as a rule in monthly installment. Vessel leasing contract in Croatia business practice are such that the general terms of business prevail and are the most important set of rights and obligations of the parties to the vessel leasing contract. Through the general terms of business, complete guidelines for the contractual relationship are given, but it also prevents the disposition of the contracting parties in negotiating the content of the rights and obligation of the specific contractual relationship. Through the general condition of business leasing company regulate two contracts differently, the one of the financial leasing and the one of operational leasing. In the relation of the contract accompanying the legal business of vessel leasing, it should be noted that they depend on the number of participants, so in theory they are divided into direct and indirect leasing, although business practice in Croatia is such the vessel leasing contracts are indirect. The peculiarities of vessel leasing are reflected in the specific condition accompanying this leasing object. This is why contracting is different for vessel than for other movables. The vessel leasing contract, on the end, in Croatian law is the result of reaction to business practice that calls for uniformity in determining the rights and obligation of the participant in the legal business of leasing that the parties to the leasing contract. Thank you.